Good evening, everyone. It's my pleasure to introduce Dr. Carson Holloway. Dr. Holloway received his BA from the University of Northern Iowa and his PhD from Northern Illinois University. He serves as the department chair and professor of political science at the University of Nebraska, Omaha, and a Washington Fellow in the Claremont Institute's Center for the American Way of Life. He is the author of Hamilton versus Jefferson in the Washington Administration, Completing the Founding or Portraying the Founding. He has been a visiting fellow in Princeton University's James Madison program in American Ideals and Institutions and a visiting fellow in American Political Thought at the Heritage Foundation. His scholarly articles have appeared in the Review of Politics, Interpretation, a journal of political philosophy, and Perspectives on Political Science. Please join me in welcoming Dr. Carson Holloway.
All right, thank you, Grace, for that kind introduction. I just want to say it's an honor to be here under the auspices of the McConnell Center, an enterprise about which I've heard much, and I know it's doing great work, and I've never been here to beautiful Louisville before, so it's a great pleasure to be here for that as well. And I'm happy to speak to you tonight about why you should read Joseph Story's Commentaries on the Constitution of the United States. Since Story and his commentaries are probably not familiar to many viewers of the lecture or those of us who are present, let me start out by giving some background on him and an overview of this, his most important work. So, Story's Commentaries, as I'm going to argue, is important in that it gives us great insight into the political and legal thinking of the founding generation. But Story himself was not quite a member of that generation. Story was born in Massachusetts in 1779, so that's well into the Revolution. It's already well underway. And so he's too young to play any important role in those great political developments, such as the securing of independence, writing and ratification of the Constitution. One way to introduce him would be to link him to somebody who certainly is very famous. I mean, John Marshall, the great Chief Justice. More people have heard of him. So Story was an associate justice on the Supreme Court during much of the time that John Marshall was Chief Justice. And they were close colleagues and friends. You could say Marshall had Story as his right-hand man in a sense. They tended to agree on constitutional and legal questions, and they admired each other. Story dedicated the commentaries that I'm going to talk about tonight to the Chief Justice, and Marshall, for his part, praised the commentaries. So that's a good place to begin, Story's relationship with the Chief Justice, John Marshall. But it'd be wrong to end there, I would say, because Story is certainly a very consequential and accomplished man in his own right. Let me summarize his political career briefly before we turn to the commentaries. As I said, Story's from Massachusetts. He served a couple of years in the Massachusetts House of Representatives. He served a couple as state attorney for Essex County. He served part of a term in the U.S. House as a member for Massachusetts, and then he went back to the Massachusetts House and served again and was elected the Speaker. Story, in terms of the partisanship of the time, was a Democratic Republican, which is to say a Jeffersonian, right? That's the party that's the ancestor to today's Democratic Party. And that also kind of makes interesting and surprising in some ways his close collaboration with Chief Justice Marshall, because Marshall was a high Federalist. So there's a partisan divide there, but they didn't really disagree on constitutional issues, I don't find. Speaking of that, in 1811, he was appointed to the Supreme Court by President James Madison. He served a long time, 34 years, which is as long as Marshall, but he didn't perfectly overlap with Marshall. He came to the court about 10 years after Marshall did and stayed after Marshall died. And Story himself ended his term on the court by dying in 1845. Most people don't know much about Joseph Story. Here's an aspect of American political and popular culture in connection to which you may know something about him. The Amistad case of 1841. That was made into a movie by Steven Spielberg in 1997, 1841 case, which Story wrote the opinion for the court in that case, in which a number of African slaves who had mutinied and taken control of the slave ship on which they were being transported gained their freedom, right? They got back to port, and Story in the court said these people are not slaves. So they were set free as a result of that. So that's one way in which he's maybe connected to a famous American historical event. Consequential member of the Supreme Court, but also Story was influential and important as a legal educator. In 1829, he became Harvard's first law professor, so he served in that position. At the same time, he was on the Supreme Court, and he was the author of numerous widely used and important legal treatises, such as, including ones, I should say, that are on very specialized topics, and I would not even venture to say you should read these. They're probably not being read by many people other than highly specialized legal historians. Like these titles are Commentaries on the Law of Bailments and Equity Proceedings. So I wouldn't venture to ask anybody to read that. I would venture, and I am venturing, to ask you to take a look at his Commentaries on the Constitution of the United States. So that's the most famous of his writings. That's the one that has the widest interest today and the most staying power. That was published in 1833. So in making my argument that you should read this, I want to narrow it down a bit, because the work itself is really massive, and it would repay reading it all, but not many of us succeed in doing that. It's in 3 books or 3 volumes. And think about what a large undertaking this would be for somebody who's also working as a lawyer on the Supreme Court. Book 1, a history of all the colonies up to the time of the Revolution. Book 2, history of the Revolution up through success and the first period under the Articles of Confederation. Book 3 gives a short history of the writing and ratification of the Constitution. And then what's most influential and what I'm recommending is a line-by-line, clause-by-clause commentary on the text of the Constitution itself. And it's that latter part that has achieved an honored place in American constitutional commentary. Supreme Court justices cite it up to the present day. They've turned to it for insight. It's been referenced in many Supreme Court cases over the decades and centuries. And I think among commentaries on America's fundamental law, you would have to rank it up there with the Federalist Papers, the product of the collaboration between Alexander Hamilton and James Madison and John Jay. In some ways, I would even say Story's Commentaries has a certain advantage over the Federalist. It has a disadvantage in that it's not written by people who participated in the ratification debates and in the writing of the Constitution itself. As I said, Story's too young for that. But the advantage is, because it's written later, as I said, in 1833, Story includes in his commentary accounts of some of the early constitutional controversies that divided the founders, such as over the Bank of the United States, the first Bank of the United States. And later on, I'll talk about the dispute over the Sedition Act. In fact, it includes, unlike the Federalist Papers, a clause-by-clause commentary on the Bill of Rights. All of that's not in the Federalist because none of it happened yet. So, narrowing down our focus, I want to argue that you should read the sections on Story's Commentaries, if you want an introduction, that deal with the First Amendment to the Constitution. Sections 1863 to 1888 deal with 2 of our most important, most fundamental freedoms: freedom of religion and freedom of speech. So why do that? I think his discussion there is very valuable because of its ability to deepen our understanding of how the founding generation thought about these constitutional principles: freedom of religion, freedom of speech, and of the press. I was about to say, maybe in another context I would say, that Story can clear up some misconceptions about those amendments. But I don't want to go that far tonight. There's no need to make that argument here. That would imply that some views are correct, others are erroneous. It probably is the case, but that's not the purpose of my talk right now. So what I will go so far as to say is that by reading Story, you would increase your understanding of the complexities of how the founders thought about freedom of religion and freedom of the press. So let me introduce that theme a little bit, and then we'll deal with it in relation to both discussions. Most modern Americans who know a little about these things hold a rather simplistic understanding of them that doesn't correspond exactly to the reality. The modern Supreme Court's told us that the First Amendment means certain things, and they generally attribute their interpretation to the founders. But as we'll see, a lot of what we've been told about what the founders thought is often only a partial account of what they thought. and we can get the rest of the story, or a substantial amount of the rest of the story, from Joseph Story's Commentaries. However, before I go on, I want to clear one thing up that could be a misinterpretation of what I just said. I don't intend those remarks about simplification and complexification about the founding and what the founders thought. I don't intend them as any kind of critique of what's often called originalism in constitutional interpretation. The idea that we have to search for the original understanding and that the court has to treat that as the authoritative understanding. I'm inclined to be an originalist myself. What I just want to say is that oftentimes the search for the original meaning is more complicated than people think, because the opinions of the founders, the framers, the ratifying generation is often more complex and diverse than we think. So it may be that some of the errors of the court in modern times come not just from not doing originalism, but from not doing it well enough, in particular on these freedoms that I'm going to discuss. All right, with that as the introduction, let's turn to what Story has to say on the First Amendment's treatment of freedom of religion. So he begins from the text itself, and here we can begin from the part that deals with what we generally call freedom of religion. So, quote, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof." That's what we get from the First Amendment on freedom of religion. And before I go on, let me have a quick aside here for purposes of clarification. You'll notice that the amendment, by its terms, only restrains the federal government. Congress shall make no law, it says. Does that mean that as far as the federal Constitution is concerned, state governments can do whatever they want in relation to church and state or freedom of religion? There's no right to that as against your state government? That was what the Supreme Court thought, and it's what the nation thought, really, prior to the ratification of the 14th Amendment after the Civil War. So that amendment, in its due process clause, prevents any state from depriving any person of life, liberty, or property without due process of law. The 14th Amendment is clearly directed at the state governments. And that language that I just quoted has been taken up by the Supreme Court over the last century as applying the First Amendment and many other parts of the Bill of Rights to the state governments. That's what's called in constitutional law the doctrine of incorporation, right? Not to be confused with other kinds of corporations or things like that, but the idea is that this particular right from the Bill of Rights, let's say freedom of religion, is incorporated into the due process clause. So the idea is that the due process clause is meant to protect certain fundamental liberties, and where do we find those? In the Bill of Rights, among other places. So we can, for the purposes of the rest of my talk, just take it that the amendment applies to government in the United States. It applies to the federal government, it applies to the state governments. There's arguments about whether incorporation was correctly decided, but I'm not taking that on in this talk. And I don't think there's anybody going back on it, because the court has held that many times over the last century. I think that's a settled question. So then, back to our substance. What does it mean to say that Congress, or whatever government, shall make no law respecting an establishment of religion or prohibiting the free exercise thereof? So let me start by saying what I think many people today think that that means. I would say most contemporary Americans who think about politics think that freedom of religion is an essential element of a society that they would regard as a just and a free one. And they think that the First Amendment is intended to protect religious freedom. They also think, and here you'll probably find this familiar, they also think that religious freedom involves separation of church and state, right? And they think that this is what the founders had in mind in writing and ratifying the First Amendment. There shall be separation of church and state. I remember, by the way, if I can depart from my script for a minute, reading a columnist when I was a kid in Iowa, reading the Des Moines Register, and the columnist said, the Constitution says quite clearly that there shall be separation of church and state. To which an answer would be, if you read the Constitution or read Story, no, it doesn't say that. It says something else. It says there shall be no law respecting an establishment of religion. So a large part of the argument is whether that language actually requires separation of church and state. But as that columnist shows, lots of people think that way because the Supreme Court has taught them to think that way. And that's the high authority that's behind that opinion. The modern court has taught this for the last 80 years. The First Amendment stands for strict separation of church and state. That's the statement of the doctrine from the court. And the court has understood this principle to mean that the government has to be neutral as regards religion and irreligion. Government should not support religion, government should not hinder religion. That's the idea behind strict separation of church and state. And the modern Supreme Court itself has a high authority, or some high authorities, for saying this, namely James Madison and Thomas Jefferson. Madison's famous as the father of the Constitution, right? That's one of his nicknames in American history. He's the prime mover also. He was at Philadelphia drafting the original Constitution, but he's also the prime mover of the Bill of Rights, which includes the First Amendment. He shepherded it through Congress so that it could be sent out to be ratified by the states. So he's an important figure. And Thomas Jefferson did not have a role in those things directly, but he was a close friend of Madison, corresponded with him while the First Amendment was being drafted. And Jefferson, certainly one of the titans among the founders. And to be fair, if you read Jefferson and Madison on this question, it's a reasonable conclusion that they were believers in separation of church and state, that they thought the government needs to be neutral as regards religion and irreligion. Certain controversies took place in Virginia while they were politicians, and they took certain stands and made certain arguments that suggest strict separation of church and state. So that, in brief, is the mostly prevailing understanding of the idea of freedom of religion or the First Amendment today. It's a traditional American idea, we think, and it's founded on what the founders wanted the First Amendment to mean. But here's where we turn to Joseph's story. I think the picture is complicated considerably if we turn to somebody like Joseph's story, who, although he's not as famous as Madison and Jefferson, still a formidable thinker about the Constitution, and whose understanding is not just idiosyncratic, it's not unique to himself. He stands for a body of thought among the founders that's different from that of Madison and Jefferson, even though this different body of thought is also held by people who believe in freedom of religion, right? So it's a debate about what freedom of religion means. It's not a debate among the founders over whether freedom of religion is important. They all think it's important, but they have different interpretations of what that requires. Put it simply, Story's understanding of the First Amendment permits the government to be a lot more pro-religion and even a lot more pro-Christianity than does the view that the First Amendment requires strict separation of church and state. I mean, Story certainly does not think that the amendment requires the government to be neutral as regards religion, and he doesn't even think that's a good idea, as I'll explain in a minute. Now, he begins his treatment of the religion clauses by surveying the history of political thought on the question of the relationship of religion to politics. That question, he says, has been very much discussed in the writers on public and political law. And then he adds this observation, so I'll quote him. The right and the duty of the interference of government in matters of religion have been maintained by many distinguished authors, as well those who were the warmest advocates of free government as those who were attached to governments of a more arbitrary character. End quote. So that's a striking comment. Story thinks that many of those people, famous writers, and he has a footnote where he lists some of them, those who are defenders of free government nevertheless also believe in a policy of government interference in religion. More than that, he even puts forward and shows respect for the view that free governments especially depend upon religion. That's a traditional argument. It goes like this. Free government means government that's limited because it doesn't have need to coerce everybody and everything. You need a police state to do that. That's not a free government. So a state of this kind requires a body of citizens who are morally upright. They have their own internal moral resources to behave well. They'll do the right thing without being coerced all the time by the fear of the law. But the next step in the argument goes, that kind of citizenry depends upon religious belief. So it follows from that chain of reasoning that government has an interest in promoting religion if it wants to be a free government. So here's this remark from Story. Quote, indeed, the right of a society or a government to interfere in matters of religion will hardly be contested by any persons who believe that piety, religion, and morality are intimately connected with the well-being of the state and indispensable to the administration of civil justice. So a free society depends upon religion. Now, is that an American view? Who would think that religion is necessary to a free society? Is it just story? No. It's the view put forward by one of the greatest Americans, the greatest American of the founding generation, George Washington, in his farewell address, in which he presents his parting advice to the country that he wanted to see prosper. So here's what Washington says in the farewell address. I just read it so you can see how much he's in the ballpark with, or on the same page with, Joseph Story. He said, this is a particular paragraph from the farewell address, which deals with a lot of other things. Of all the dispositions and habits which lead to political prosperity, religion and morality are indispensable supports. In vain would that man claim the tribute of patriotism who should labor to subvert these great pillars of human happiness, these firmest props of the duties of men and citizens. The mere politician, equally with the pious man, ought to respect and cherish them. A volume could not trace all of their connections with private and public felicity. He continues, let it simply be asked, where's the security for property, for reputation, for life, if the sense of religious obligation desert the oaths, which are the instruments of investigation in courts of justice? And, Washington concludes, let us with caution indulge the supposition that morality can be maintained without religion. Whatever may be conceded to the influence of refined education on minds of peculiar structure, reason and experience both forbid us to expect that national morality can prevail in exclusion of religious principle. So there's George Washington, thinking along the lines that Story also thinks a couple of decades later, 3 decades later. So thinking in this way, Story then suggests that the real question is not whether the government has a role to play in promoting religion, but how far it may properly do it. What are the limits? And so Story, again, in this section where he's dealing with political theory, before he turns to the amendment, he sketches 3 possibilities. So I'll list them here. He says, one is, government affords aid to a particular religion, but leaves all persons free to adopt any other religion. That's one. 2, he says, government creates an ecclesiastical establishment, that's the national church, for the propagation of a particular religion, leaving alike freedom in others. So other people can start their own churches, but there will be an official church. And then 3rd, he says, a possibility is, government creates an establishment of religion and excludes all persons not belonging to it from public honors, trusts, and privileges of the state. So all of those are inconsistent with the modern theory of separation of church and state. But it is important to notice, especially in view of how illiberal it sounds to us, especially the last one, right? I want to observe that Story frames the options in such a way that there's at least a minimal respect for freedom of religion. So consider the 2 options he doesn't even bother to discuss. On the one hand, since he thinks religion's necessary to a free state, he doesn't even venture the view that it's just none of the government's business. We're not going to have that. That's clear from what he's already said. But on the other hand, he does not suggest that a government, in trying to promote religion, could deprive people of their natural rights. I think that's important to note. Life, liberty, and property, the rights protected or mentioned in the Declaration of Independence. The most restrictive alternative he'll talk about is one where the state establishes an official church and then excludes persons who don't belong to it from their political rights, voting, holding office, things like that, but not their individual rights as human persons entering into contracts, holding property, getting married or not getting married, things like that. The Story goes on to note, turning to the history of this question in America, that every American colony encouraged Christianity to some extent. And even some of the states under the new Constitution continued to encourage religion. He cites the Bill of Rights of Massachusetts, which affirmed the duty of the government to support religion as necessary to morality and the happiness of the people. So for Story, the pre-Constitution history of America suggests the traditional view that government support for religion is okay in general. And then coming back to the First Amendment's religion clauses, Story concludes that they don't require strict separation of church and state. That's my application of his thinking to the current terminology, right? But you can tell he doesn't think that. He doesn't think the government should be neutral as regards religion. So that's not correct, according to him. But on the other hand, he is a defender of religious liberty because he thinks the amendments clearly do require that. He says that in his view, public opinion at the time of the adoption of the First Amendment probably held that, quote, Christianity ought to receive encouragement from the state, so far as was not incompatible with the rights of conscience and the freedom of religious worship, unquote. Or as he observes elsewhere in his own account, Story says, the duty of supporting religion, and especially the Christian religion, is very different from the right to force the consciences of other men or to punish them for worshiping God in the manner which they believe their accountability to him requires. So in other words, for Story, the First Amendment Establishment Clause, that's the first part, dealing with religion, clearly does forbid a national church. The founders thought that was a prudent precaution because of the religious diversity of the country at the time. It's mostly made up of a variety of Protestant sects, Christian sects, there's Catholics as well. And they thought it's wise to forestall any kind of political competition and conflict over establishing a national church that could happen if that was permitted constitutionally. So they took that off the table. But at the same time, he doesn't think that taking an official church off the table prohibits the government from showing some support for religion and Christianity in particular. So he seems to be of the view, as is evident from the three scenarios he talked about earlier when he's talking about political theory, that support for religion does not equal a religious establishment. The latter term means an official church, which you can avoid while still giving some generalized support to religion. On the other hand, the Free Exercise Clause clearly means that whatever the government does to support religion must not intrude on the rights of conscience or of religious worship. So individuals have to be left free to believe whatever they think is true in the realm of religion, and they have to be left free to join together to worship under the auspices of their religion. One more point on the Constitution and religion, but moving beyond the First Amendment. We saw that Story held it out. I talked about it a few minutes ago. He held it out as a possibility, theoretically, that the government might prohibit members of a disfavored religion from holding public office. Well, would he think that's just? It's clear that he doesn't think that's just. He mentioned it as a way of summarizing the different opinions that have been entertained, but he doesn't think that's a correct way to go. His discussion of England, he condemns England very seriously and sternly for imposing on Catholics and Protestant dissenters from the Church of England certain political disabilities. And he notes with approval that apart from the First Amendment, there's a passage in the original Constitution that forbids religious tests for office, right? There's a no religious test clause even before you have a First Amendment. So that in turn protects not only the natural rights, the civil rights, if you want to call them that, of citizens, but also their political rights as well. You can't be disbarred from holding office by not being of the majority religion. So, to sum up, even though Story thinks there's nothing wrong with the government supporting religion and nothing unconstitutional with that, even Christianity in particular, it's still possible and it's still necessary and just, and it's still required by the Constitution that you protect religious liberty, understood as the conscience rights and the freedom of worship rights of individuals. All right, that's what I want to say about freedom of religion. Let's turn to the other half of the amendment. Not the other half, because there's some other things about freedom to petition and assembly that I'm not going to talk about. They don't cause as much controversy, and Story himself doesn't say as much about them. The other big piece of the First Amendment is freedom of speech and of the press. Congress shall make no law abridging the freedom of speech or of the press. So I think the situation here is very similar to that relating to what we just talked about, freedom of religion. Contemporary Americans have a view of what freedom of speech and of the press should mean. It's a view they've been taught by the Supreme Court over the last several generations and taught in the name of the founders, as if the founders hold this certain view. But if you look more closely, meaning if you look at Story, you find that the matter's more complicated than you would think. So I think in the last couple of generations in America, you could say that the dominant understanding of freedom of speech and of the press has been very robust, right? I almost want to say, it would go too far to say this, but let's say it, because as a teacher of mine used to say, it goes too far but in the right direction. So throw it out there to establish a certain understanding and then admit there's a qualification to it. I almost want to say modern Americans believe in free speech absolutism, right? You say whatever you want. That's what freedom of speech means. Now, it doesn't go quite that far because everybody will admit that there are practical limits that have to be observed. I think it's fair to say that many people in America in modern times have assumed that the constitutional protection for freedom of speech and the press means you can say pretty much whatever you want, right? And certainly if the government is trying to stop you, the first thing they'll say is, that's a violation of my constitutional right to freedom of speech and of the press. And the modern Supreme Court has been a teacher of this view. The history of the court's handling of the First Amendment over the 20th century is a history of increasingly powerful protections or increasingly severe limits on the government's ability to restrict speech. It depends on how you look at it. The protections are increasingly powerful for the right, but the authority of the government over speech is being contracted at the same time. So, a couple of examples. In the 1920s and before, the Supreme Court and the courts in general would not intervene much in cases in which laws regulated speech. You could get in trouble for radical political speech. Radical speech understood as speech advocating change in the government by extra-legal means. Then later in the 20th century, the court moves toward other tests, like the so-called clear and present danger test or the imminent lawless action test, that are much more protective of such radical speech. They mean, in effect, that you can say whatever you want as long as there's no immediate danger that anybody will act on it. Or in the area of libel, defamatory speech or publication. Prior to the 1960s, libel standards in America and First Amendment standards held that libel is a category of speech just not protected by the First Amendment at all. It's outside the scope. And that meant that in the old days, public figures, public officials, candidates for public office could and sometimes did successfully sue newspapers for defaming them. In 1964, in New York Times versus Sullivan, a pivotal case of the Warren Court, the court held that libel cases involving public officials do implicate the First Amendment. And they create a danger to the vigorous discussion of ideas that the First Amendment's meant to protect. And so they devised a new standard called the actual malice standard. That standard means that if you're a public official or a public figure and you want to sue a newspaper or anybody for libeling you or defaming you, you have to not only show that it was false and defamatory, you also have to show actual malice, which means that the publisher knew it was false when they published it, or at least they acted with reckless disregard for the truth or falsity. That means in practice that it's really hard for public officials and public figures to sue anybody successfully for libel. So that's another area in which the protections have become much more favorable to the speaker or the publisher. One last thought on this modern scene. You can get a sense of where the modern Supreme Court has ended up on these questions by considering a 2011 case, not that long ago, Snyder versus Phelps. So this case involved a lawsuit against the Westboro Baptist Church, which was famous or infamous at the time for using the funerals of American military personnel who'd been killed in combat as an occasion for the church's protest against what they thought was the moral decay and decadence of America. So I'm not going to quote what they said, it's not very nice, but leave it at this. They would use the funeral as the occasion for their protest. They would say things very negative about the military person being buried, personal, abusive, directed at that person and at the family, right? And so, being subjected to this, one family sued under various state torts, like invasion of privacy, infliction of psychological harm, things like this. And the court said, this is First Amendment protected speech. And they said what they always say in these kinds of cases, that the First Amendment exists to protect even speech that a majority of Americans think is morally outrageous, right? And also noteworthy about this case is that it was 8-1. Only Justice Alito dissented. So what that tells you is that this very robust protection, or this near First Amendment absolutism, is not really a partisan or an ideological issue for the justices of the court. The liberal justices believe it, the conservative justices believe it. There's been a lot, just an aside here, many people know about the personal friendship of, say, like Justice Scalia with Justice Ginsburg. they disagree on so many things. I think this is the kind of thing they would agree on. The First Amendment protects even speech that the majority finds outrageous, morally outrageous. A common view. But if we turn to Story's commentaries on the Constitution, we find a much different view. Story also believes in freedom of speech, but it's a much less robust understanding of the individual protections than we have today. Or, if you want to put it the other way, it's a lot more deferential to the government's authority to regulate speech for the sake of the common good and public order. So again, as in the case of religion, that doesn't mean that Story doesn't believe in freedom of the press or freedom of speech. He values it. He makes a point of saying how important it is and how lucky we are to have it, and surveying in a couple of paragraphs countries that don't have this protection, and you can't share your ideas, you can't criticize the government. He says all that's bad. But he would emphasize a lot more than we would the limits on freedom of speech and of the press. So, for example, he begins his account by quoting the relevant language of the First Amendment: Congress shall make no law abridging the freedom of speech or of the press. And then immediately, right out of the box, he adds this: that this amendment was intended to secure to every citizen an absolute right to speak or write or print whatever he might please without any responsibility, public or private, is a supposition too wild to be indulged by any rational man. Right? So to back that up, who does he turn to? He turns to William Blackstone, the great commentator on English law, the English common law, which had influenced American conceptions of liberty. Blackstone also praised liberty of the press. He said it's essential to the nature of a free state. But Blackstone insisted on a distinction, a very familiar one, an important one to the founders, between liberty and licentiousness, or liberty and license. And Blackstone said acts of licentiousness are open to legal punishment. And Story, by the way, made it clear that he agreed with this view and thought it consistent with the First Amendment. There's a passage, a very important one, I think, in the commentary where he says, the abuse of a right is something essentially different from the use of it, right? And he says, the abuse is not protected. The use is protected. Let's go back to Blackstone for a minute. What did he mean by liberty of the press? Blackstone held that the core meaning of liberty of the press was freedom from prior restraint, right? That means the government could never stop you from publishing anything, but it certainly could punish you after the fact or permit a lawsuit after the fact if what you published was licentious. Here's Blackstone, quote, every free man has an undoubted right to lay what sentiments he pleases before the public. To forbid this is to destroy the freedom of the press. But if he publishes what is improper, mischievous, or illegal, he must take the consequences of his own temerity. So to prevent publication, that has to be rejected according to Blackstone, because that gives the censor an arbitrary power over the expression of opinion. And interestingly too here, let me just add, if you think about the American system of separation of powers and the English system of separation of powers, Blackstone is objecting to prior restraints and censorship in the strict sense because it gives an executive branch official an arbitrary power to just like take stuff and say, nope, you can't publish that, this you can, right? That's different from the other option, which is this. He continues and says, to punish any dangerous or offensive writings, which when published shall on a fair and impartial trial be adjudged of a pernicious tendency, is necessary for the preservation of peace and good order, of government and religion, the only solid foundations of civil liberty. So it's fundamentally different for him, and I think for Story too, to punish somebody after the fact, because that's not the arbitrary judgment of an executive branch official. That has to be taken into court and proven according to legal standards with a judge and a jury. So there's more protections for liberty there, even though you can be held to account after the fact. So I think, yeah, Story agrees with Blackstone on that, and he's not alone among the Americans of the time. So for example, he observes that even though we have the First Amendment, even though the states, not all, but most of them have constitutional protections for liberty of the press, says there's no state court up till now, that'd be 1833, that's repudiated Blackstone's understanding, right? Americans know Blackstone. They read him to prepare for legal studies. He's a very influential writer. And it's striking that up to 1833, Story says, no American judge has suggested that Blackstone was wrong about freedom of the press. There have to be limits. Another sign that Story was not alone in this more restrictive view of freedom of the press can be found in the controversy over the Sedition Act of 1798. The Sedition Act was passed by the Federalist Congress, signed into law by President John Adams, and it made seditious libel a crime. What is seditious libel? In the definition of the act, it's false and defamatory claims about the government or about government officials. The president's named, for example, but the federal government in general. So the Sedition Act was very controversial. It was condemned as unconstitutional, inconsistent with the First Amendment by very great people, ones I've already mentioned, Thomas Jefferson and James Madison. And I think it'd be fair to say that Jefferson and Madison have a more expansive understanding of freedom of the press and of speech than somebody like Story and Blackstone. But the point I'm trying to make here is that as Story observes himself, a lot of very reputable Americans did think that the Sedition Act was constitutional. He doesn't name any names, but I'll name a few. George Washington, Alexander Hamilton, James Iredell, who's a member of the Supreme Court. They thought the act was constitutional, which is, by the way, a different question of whether it was a good idea or maybe it went too far, but they didn't think it violated the First Amendment. So here's how Story sums that up. The act, he's looking back from 1833, right? He says, this act, the Sedition Act, was immediately assailed as unconstitutional, both in the state legislatures and in the courts of law, where prosecutions were pending. Its constitutionality, however, was deliberately affirmed by the courts of law. So these cases went forward, and courts heard arguments that it was unconstitutional, and they said, no, it is constitutional. It didn't get to the Supreme Court, but it was heard in federal courts. He says, it was denied, the constitutionality of it was denied by a considerable number of states, but it was affirmed by a majority, right? You may know this, and I'll just mention it quickly. In opposition to the Alien and Sedition Acts, Jefferson and Madison wrote the Kentucky and Virginia resolutions, which were condemnations of them. And they're very spirited, they're very tough, they're very intelligent, but they shipped them around to the other states, hoping the other states would join the condemnation, and a lot of the other states said, no, we're not going to. And a lot of the other states passed their own resolutions saying, we think the Sedition Act is fine, and the Alien Act. So, to sum that up, judgments about the Sedition Act at the time it happened were mixed, right? And it goes to show that there was a substantial body of American opinion at the time of the founding that agreed with this more restrictive understanding of freedom of speech and of the press, the kind of Blackstone understanding. So, to wrap it up, the general lesson of this discussion of the First Amendment, both freedom of religion and freedom of the press, is that if you want to think more critically and more independently about these fundamental freedoms, you have to go deeper into history and not just rely on what you've been told about it by the modern Supreme Court. And that is a good reason why you should read Joseph Story's Commentaries on the Constitution of the United States. Thank you.